Ladies and gentlemen, participants, arbitration essentially is private litigation. And it stands to reason, therefore, that if arbitration is going to be attractive as an alternative, then it must have certain advantages over its more public counterpart to make it attractive. These advantages have variously been noted as the speed, economy, informality, technical expertise, and also the awards which are final and binding. In order that the arbitration process can fulfill these promises, it needs to deliver on three key elements. First, the ability to have arbitration agreements recognized and enforced. Secondly, the ability to ensure that the arbitral process is carried out efficiently with minimum interference from outside sources. And thirdly, the recognition and enforcement of valid arbitral awards in a timely fashion, and also providing a means of rectifying and, in extreme cases, setting aside invalid or flawed awards. Unfortunately, it is precisely in the delivery of these three key elements that the process is most vulnerable. It has to depend on the goodwill of state courts, which are mandated to carry out certain roles in the arbitral process. It is for this reason that if arbitration is to thrive in any jurisdiction as a viable alternative process, there needs to be a deliberate policy of judicial support for the process. Ghana prides itself as a jurisdiction that supports arbitration, and it is one of the early signatories of the New York Convention. And to emphasize this, more recently in the year 2010, Parliament enacted the Alternative Dispute Resolution Act 798 for the purpose of bringing the law governing arbitration into harmony with international conventions, rules, and practices. One would ask then that with such a rich background or rich historical background in arbitration, is there a need for a program such as this to talk about fashioning a deliberate policy for supporting arbitration in Ghana? In truth, however, arbitration statutes are but a surface manifestation of the status of arbitration in any particular legal system. The legislative endorsement can consist of facial rhetoric and oftentimes constitutes a merely symbolic gesture of adherence. The true measure of a state's support for arbitral processes resides in the judicial implementation of the regulatory provisions on arbitration. It is the court's decisions in decisive issues of the law and the practice of arbitration in areas such as arbitrability, the separability of the arbitration agreement, the powers of the arbitrator, and the enforcement of arbitral awards that the jurisdiction's true support or abhorrence of arbitration is shown. Statute proclamation only gain real meaning in court decisions and nothing else. To use one glaring example, which I'm sure a lot of the participants would mention, there is an infamous case of the Attorney General versus Vulcan Energy Limited, where just 2 years after the enactment of the ADR Act, the Supreme Court sought to question one of the key pillars of arbitration, the separability principle. It is to prevent such contradictory decisions that we believe it is necessary for academia, the bench, the bar, and arbitration practitioners to meet at fora such as this. It is more imperative if we consider the fact that in several instances when an application for judicial intervention is made, it is from the decision of an experienced arbitrator, well versed in the law and practice of arbitration, to a judge who, in spite of his excellence and brilliance in other fields, may very well be inexperienced in the field of arbitration. Indeed, alternative dispute resolution and arbitration was not a course of study for most of the judges who are now sitting at the commercial courts, Court of Appeal, and Supreme Courts. Apart from the frequent trainings that they are given through the Judicial Training Institute and other such occasions, some of the judges may have had very little exposure to the law and practice of arbitration. In such a situation, when a judge sits on an arbitration-related matter and gives a decision, that decision is deemed to be right not because of the depth of knowledge that was brought to it, but just because it is assumed and taken to be that the law resides in the bosom of the judge. I know I'm getting close to contempt of the court. The Court of Appeal and Supreme Court are ably represented, and so I will leave it at that. And so this colloquium is designed to engender a discussion of the provisions of the ADR Act, which provides for court intervention in arbitral proceedings in Ghana, with a view to discussing the principles that underlie these provisions and offer guidance to the bench, bar, and academia on the interpretation of the provisions in a manner that lends support to arbitration and brings us into the best practices of arbitration as envisaged by the ADR Act.